Brilliant. Hello, everyone. We're going to wait a couple of minutes just to make sure that everyone is in and joined, and then we will start. Any questions or issues with sound, please feel free to pop them into the chat, and one of the moderators will pick it up and help.
Okay.
All right, thanks, everyone. I'm sure a few more people will trickle in, but we'll get started. Let me share my screen. Okay. Brilliant. So good afternoon, everyone, and a really warm welcome. Thank you so much for giving up your time to be with us today. My name's Yasmin. I'm in business development at Home Finders, and I'll be hosting today's session. We've been preparing this webinar specifically because the number of landlords contacting us with questions about the Renters' Rights Act has never been higher. And we wanted to give you a proper, comprehensive briefing rather than just a headline summary. I'm joined today by two brilliant people. First, Melissa, our lettings director. Melissa has been guiding our landlords through the legislative changes. She knows what works in practice, not just in theory. And we are really fortunate to have Martin Ashley Taylor with us. Martin is the managing director of Ashley Taylor's Legal. He joined the law in 1973 and has over 10,000 landlord and tenant cases behind him. He is, without question, one of the most experienced people on this subject, and he's giving his time to us today. So please make good use of him. We have a full agenda, and by the end of this session, you will know exactly what's changing, what you need to do, what the risks are, and importantly, what the opportunities are for landlords who get this right. So a quick bit of housekeeping before we dive in. Questions, please keep them coming throughout. You can use the chat or the Q&A panel at any point. This function is located on the right-hand side of your screens. Our moderators are watching and will respond back to you or cue them for the right speaker. You don't need to wait until the end to ask questions. Additionally, if you want the screen a little bit bigger, there is a full screen option which will be in red at the bottom of your screen. If you have any queries, please put it in the chat and our moderators will be able to assist you. If we or our moderators don't get to your question live, we will respond by email, and we'll also collate all the questions and answers we get today and send it out to attendees via our newsletter. With 10,000 cases behind him, Martin, I'm sure, will spark quite a few questions, so he's agreed to respond to these by email after the session. Another thing, don't take notes, sit back, focus on what's being said, and we'll follow up with everything. So we want to start with something that might surprise you, because we know how many of you have been anxious about what's coming. I've been having this conversation with landlords every day. But look at this timeline. Every single one of these moments felt enormous at the time. In 2007, deposit protection schemes were made mandatory. Landlords panicked about the admin, the fines, the complexity, but we navigated it. In 2008, EPCs became mandatory for rental properties. In 2012, civil penalties were introduced for landlords. In 2015, new Section 21 and prescribed information rules. In 2016, the 3% SDLT surcharge that everyone said would kill the market was introduced. In 2020, compulsory EICR checks, and simultaneously, the phased removal of mortgage interest relief. That was two major changes in the same year. Every single time, the landlords who worked with a professional letting agent who had compliant processes, correct documentation, and proper insurance came through in a significantly stronger position than those who tried to manage it alone. The ones who suffered were the ones who didn't take it seriously in time or who tried to cut corners. We saw self-managing landlords fined for deposit protection failures 10 years after the legislation came in, because no win, no fee solicitors found them, and we're actually still seeing that happen today. 2026 is unquestionably the biggest change in this timeline, but the principle is identical. Understand it, prepare now, and work with the right professionals. The landlords who are calling us right now are the ones who will be fine, and that's all of you, so you're already ahead. So, what is the Renters' Rights Act? It received royal assent on the 27th of October 2025. It is law, and it's round the corner from us now. The first and most significant phase comes into force on the 1st of May, which is just weeks away. This is, and I don't use this lightly, the biggest overhaul of the private rented sector in over 30 years. The last time the law changed this fundamentally was the Housing Act of 1988, which introduced the AST in the first place. This act ends the AST. That's the scale of what we're talking about. It will affect 11 million renters in England and every single private landlord. There's 3 core pillars. First, security for tenants. This is where Section 21 and fixed-term tenancies are abolished. Second, higher standards. Decent home standard, AWAB's law extended to private landlords, and an EPC rating of C required by 2030. Third, accountability and enforcement. A compulsory landlord database, a new PRS ombudsman, and significantly strengthened powers for local authorities to fine and prosecute. There's 3 phases of rollout. Phase 1 on 1st of May, that's the one that changes everything operationally, every tenancy, every possession process, every rent increase. Then there's phase 2 in late 2026, which brings the database and ombudsman. And phase 3 from 2030 brings us updated property condition standards. So here's a statistic that actually surprised me when I first saw it. 77% of tenants can already identify at least one proposed change under this act. That means tenants know this is coming. They know their rights are changing and they are preparing. Landlords cannot afford to be less informed than their own tenants. The consequences of getting this wrong are not administrative inconveniences, they are real financial penalties. Rent repayment orders going back 2 years, and in serious cases, criminal prosecution and banning orders. Rightmove, which is not a campaigning organisation, has publicly recommended that landlords work with a professional letting agent as the most effective way to stay protected. That recommendation is sitting on one of the most visited property websites in the country, and tenants are reading it. There is a critical deadline that catches many landlords off guard. By the 31st of May, that's just 30 days after the Act comes into force, every existing tenant must have received the official government information sheet. Not a summary, not a link to a website, the exact PDF downloaded from gov.uk sent as an attachment. It is important for self-managing landlords to review their current tenancy agreements to confirm how notices can legally be served on tenants. As this document must be delivered in accordance with those terms, if you have any questions regarding your tenancy agreements, please contact us using the link. One of my colleagues will pop up below. Here is a part that surprises landlords. If you use a managing agent, we also have a legal obligation to serve that document too. Even if you've already done it, it lands on us as well. At Home Finders, we are already preparing for this. We have the processes in place, and for a landlord managing this themselves, this is one of the first tests of whether they can keep up with the compliance requirements of the new regime. So the scope of the Act, this question comes up constantly. The Act is focused entirely on the private rented sector in England. Every private landlord letting residential property is affected. It doesn't matter whether you have 1 property or 50, whether you self-manage or use an agent, whether your tenancy was signed last week or 5 years ago. This applies to all existing tenancies, not just new ones created after the 1st of May. And let me be very specific about this because it's probably the most common misconception we encounter. If you are currently 12 months into a 24-month fixed-term tenancy, on the 1st of May, that tenancy becomes periodic. Overnight, no notice period, no transition, it converts automatically by operation of law. And there's a wider strategic point here. Previously, as a landlord, you could plan around a fixed end date. You knew when a tenancy ended, you could plan a sale, a refurbishment, a new tenancy. Under the new regime, possession is reasons-based, not timeline-based. You cannot plan around a date anymore. You plan around a legal ground. That is a fundamentally different way of managing a portfolio, and it requires professional support to do well. Social housing, commercial lettings, and holiday lets are outside the scope. But if you're on this call, you are almost certainly affected in some capacity. So I'll hand over now to our lettings director, Melissa, to dive in a little bit deeper.
Thank you, Yasmin. Now, let me talk you through the specific legal changes, and I'll start with the tenancy terms, because this is the most fundamental structural shift. Fixed-term tenancies are abolished. From the 1st of May, you cannot enter into a new fixed-term assured tenancy. It is not simply inadvisable, it's a breach of the Act and carries financial penalties. Every existing AST automatically converts to a periodic tenancy on that date. Periodic means the tenancy rolls on a month-to-month basis with no fixed end date. The tenant has no minimum commitment. They can serve 2 months' notice to leave from the first day of the tenancy. In a worst-case scenario, a landlord could be required to relet their property up to 6 times in a single year. Following discussions with our clients, we have reviewed and updated our management services to help address these concerns. As a result, we'll now include unlimited relets per year, helping to alleviate our landlords' worries around potential increases in lettings costs. There is also a new written statement required. So for all tenancies beginning on or after the 1st of May, landlords must provide tenants with a prescribed written statement of key tenancy terms. The detail of exactly what must be included is now set out in secondary legislation. If you're not managing this through a professional agent, getting this wrong from the outset could invalidate notices later. Now, rent in advance, this is something I know many landlords have relied on, particularly for higher risk applicants, taking 3 or 6 months and sometimes even more upfront. Under this Act, you legally cannot accept more than 1 month's rent in advance. Even if the tenant offers more and even if they insist, it's unlawful for you to accept. I want you to sit with the implications of that for a moment. The advanced rent buffer that many of you have used as informal protection against arrears is gone. What replaces it is proper referencing, rent guarantee, and legal expenses insurance, which we'll expand on this further in a moment. But those 2 things are now your primary line of financial defense. The arrears scenario can sometimes look pretty stark when you put the numbers together. Do you want to give everyone a sense of that exposure?
Yeah, the numbers are significant. Under the new regime, it's 3 months to reach the arrears threshold before you can even serve notice, up from 2 months. Then it's a 4-week notice period. Then an average of 28 weeks in court. That's potentially 12 to 15 months of lost rent on a single bad tenancy. Without rent guarantee insurance, that is an uninsured loss sitting against your portfolio. We do include RGI as part of our full management package specifically because of this. I think Martin might be able to expand on this and reassure us further. Martin, do you have anything to add to this?
I'll probably deal with all of that in the main thing there, but just on the rent in advance, you're quite right, no more than 1 month. Tenants, if they offer you more, then you can't take it. But, and there is a but you don't want to be getting involved too much in this. If the tenant after the 1st month wants to pay you not a higher rent, but several months' rent, voluntarily, they can do that. They don't just have to pay 1 month, but you can't ask them to do that. So don't get yourself in a situation where you're asking them and it can be proved, because that's just going to be fatal. But the 1 month's rent is what they can pay. If they want to pay after that 1 month more than one, they can. Just to remind you, once you can't take that rent until the agreement's signed. And once the agreement is signed, whether or not they've actually paid the rent, they actually have the right to occupy. So I know you'll think straight away, well, they're going to sign and they're going to go in and they haven't paid any rent. Everything's possible. But if you work it so that you can try and do it in office, or you can do it simultaneously signing and getting the rent, that's a good idea. You can buffer against it a little bit, actually, because holding deposits are not often taken, yet the law does allow them. So you can take the deposit and take a holding deposit. Don't forget, you've got to offset the holding deposit against the 1st month's rent. But if they don't pay, at least you've got some recompense against that whilst you're then trying to get them out. But that's the only key thing I'd say about that. The rest I will put together when I talk about grounds later on.
Brilliant, thank you, Martin. Really good point there from Martin about not being able to take rent before the agreement is signed by both parties. So the rent guarantee insurance that we have actually covers this as well. So arrears from day one, like Martin said, it's always a possibility. So if a tenant were to sign but then fail to pay their move-in monies, which could happen, you'd still be protected Same with holding deposit, which is a great idea. So on to the next slide, which is rent increases. There are some elements here that most landlords might not know yet, and it can cost money if it's missed. So from the 1st of May, the only lawful mechanism for increasing rent is a Section 13 notice. Any rent review clause you have in your current tenancy agreement, whether it says it increases by a fixed percentage or at a review date, those clauses would be void. It has no legal effect and you cannot rely on it going forward. The statutory process is the only route. You can use a Section 13 maximum once per year with 2 months written notice, which is up from 1 month. If a tenant challenges your rent increase at first tier tribunal, where there's small cost to tenants to take it there, there's no real downside for them. The new rent does not come into effect from the date your notice expires. It comes into effect from the date of the tribunal's rulings. Hearings can take months to be listed. That means a tenant can delay your rent increase by simply submitting a challenge and waiting. With rent guarantee, especially R1, if the FTT rule in your favour, the increased rent will be backdated to when the notice expired. You obviously have to support your proposed increase with genuine market comparables. An index-linked formula or a portfolio-wide percentage uplift just isn't sufficient enough if it's challenged. You need recent lettings of similar properties in the area, amongst other things. Obviously, setting the rent right from the outset with solid market evidence is very important as well. So this is the exact kind of process that we manage on behalf of our landlords. So we handle every Section 13 notice, build the comparable evidence, and track tribunal proceedings. Our landlords don't have to think about it; it's just handled. Now, Martin, is there any advice that you can give landlords with the new structure on rent increases?
Yes, because it's quite interesting. So firstly, just to remind people, this Section 13 notice, it's called a statutory notice. And that means that what a statutory notice means is that the Act publishes what the notice looks like. So you can't make your own notice up. You have to use the notice published by the government. So if you're going to use it, you've got to download that notice because no other notice is valid. You're talking about the LVT. Not the quickest of organisations, and yes, you've got to wait for the LVT finding, and the LVT can either agree lower or higher the rent, just lower the rent, but they can also defer the rent increase for 2 months from their hearing date. Now, I can see people thinking, well, every tenant is going to challenge the rent. Why not? Because you've got nothing to lose. The rent can't increase until the LVT finds out. However, if bearing in mind your rent increase has to be within the local market rental rate, when you submit your Section 13 notice to your tenant, giving them 2 months notice, you could, after doing that, write to them separately and just say, you've got my notice. We're increasing, let's just use easy figures. We're increasing the rent from 1,000 a month to 1,100 a month. However, if we're able to agree early a rent of 1,057 a month, then I'm happy to do that. Now, why would we do that? Because if you have got a separate agreement after your Section 13 for a lesser amount, and I don't mean £1 or £2, you've got to be a little bit sensible about this, then, and they agree to do that, then in fact that actually takes away the ability of the LVT to actually assess the rent. So you've agreed a lesser amount. So £1 or £2 isn't going to do it. Get sensible about it, make sure it works for you, but probably what that would do is that would get your rent increase on the time you want it. Because this is to add on one other thing there. Your rent increase can only happen annually. That's not quite how it reads, actually. You cannot re-increase your rent for a period of 12 months from the last rental increase. So if your rental increase, we want to do it now, and the people go to the tribunal and you don't get a tribunal result till September this year, then your next rental increase, if you try, is going to be September next year, not April this year. So a few little tweaks there to think about. But But if you are thinking of doing that Section 13, you've got to use that notice. Any other thing is not going to work. There you go.
Brilliant. Thank you, Martin. Yeah, so on to the next slide. There are 3 more changes that are going to affect how you market and let your properties on a day-to-day basis. So rental bidding is banned. This means you have to advertise at a fixed specific rent, not a range. You can't accept, encourage, or imply that offers above the advertised rent are welcome. This falls on letting agents as well as landlords. There is a provision that works the other way. So if a property is let above the market rate, tenants can apply to first tier tribunal within the first 6 months to have the rent reduced to the market rate. So it's important to be able to trust your letting agent's market appraisal here. Pets. So I know this probably worries a lot of landlords. Just want to reassure you, it's probably the least of your concerns under this act. Tenants can request permission to keep a pet, and you have 28 days to respond in writing. Any refusal must be reasonable and supported with clear evidence. So for our managed landlords, we handle this process for you. When a tenant submits a request, we'll provide you with a step-by-step guidance and templates, including legitimate refusal grounds. For example, if a certain breed is too large for the property, along with the tenant's completed form to help you make an informed decision. New protected categories are now introduced and explicit in law. So a tenant cannot be refused because they have children, receive universal credit or housing benefits. Refusals are only permitted on genuine evidence grounds, such as affordability or lawful overcrowding. Blanket no DSS or no children policies are not allowed. Our references process identifies affordability issues and does allow for lawful rejection where appropriate. When we handle tenant selection, we do it with documented, legally defensible decision making on every applicant. Every refusal is recorded against a lawful reason. That protects our landlords completely from any claims. On to the next slide. We're looking ahead to phases 2 and 3. Because even though these aren't in force yet, the time to plan for them is now, not when the deadline arrives. The decent home standard will extend to the private rented sector for the first time. This sets minimum standards for the condition and safety of rented properties. Most properties under professional management will be at this standard already. The current consultation will suggest that full implementation will be between 2030 and 2035. Additionally, an EPC rating of C is required across the PRS by 2030. AWAB's law is named after Awab Ishak, a 2-year-old child who died as a direct result of prolonged exposure to mold in a social housing property. This act extends this law to the private sector. Landlords must investigate and repair serious hazards, particularly damp and mold, within strict statutory timescales. Failure to comply exposes landlords to compensation claims from tenants, fines, RPOs, etc. Local councils are also going to be increasingly incentivized to civil penalty notices as the fines directly fund them. We'll go into this in more detail on a later slide. So Yasmin, based on everything we've discussed, what can landlords do to protect themselves?
Yeah, I mean, I think this is why having a professional agent who manages the maintenance, keeps records, and responds to repair requests promptly is so important. Obviously, with us, our maintenance coordination is designed specifically to create the audit trail, investigate and respond to damp, mold, and serious health issues within the statutory timeframes that protects our landlords from exactly this kind of enforcement action.
Realize I was on mute. On to the next slide. Now, we're going to discuss ending tenancies. This is where we are finding the anxiety is highest for landlords and where the stakes are most significant. Section 21, the no-fault eviction, is gone from the 1st of May. The 30th of April is the absolute last date to serve a valid Section 21 notice. If you have a tenancy where you need to recover possession and you haven't served it yet, you need to act today. After that date, every single possession claim must be under Section 8. In a couple of slides' time, Martin will cover the new statutory grounds, which is up to 37 from the 17 currently. So using a solicitor like Ashley Legal is the safest route for landlords. If you want to inquire about their services, there is a link below that you can click to go there. Let me give you a real-world arrears scenario that every landlord should understand. Your tenant stops paying rent. Under the old system, you might serve a Section 21 notice. It's clean and quick. Under the new system, you have to wait until they reach 3 months of arrears before you can serve notice on the mandatory arrears ground. Now, without rent guarantee and legal expense insurance, that's an uninsured loss. So for a property where, keeping it simple, like Martin said, the rent is £2,000 per month, that could be about £25,000 to £30,000 in lost income, plus any legal costs. So quality tenant referencing, rent guarantee insurance are now the most important financial risk management tools a landlord has. And both of those sit within our professionally managed services as well. It's also worth mentioning how enforcement will work under the new act. So councils are under significant financial pressure, and the legislation places a new statutory duty on them to enforce landlord compliance. This enforcement is supported through civil penalty notices, which fund their activity and encourage a more proactive approach rather than one driven purely by complaints. This isn't intended to concern responsible landlords, but to ensure consistent standards across the sector and address poor practice where it does exist. Councils are in serious financial difficulty. Many are effectively bankrupt. They're actively looking for revenue streams. So they're going to ask landlords, letting agents for specific documents, and they've already had the investigative powers from 27th of December 2025. So this is a risk with self-managing landlords where gaps in documentation can leave properties exposed to tenant challenges. Deposit protection has been a legal requirement since 2007, yet we are still seeing claims related to self-managing landlords and their deposit failures in 2026. So penalties, there is a £7,000 per fine per breach for most offences. This rises to £40,000 for serious or repeat breaches. The most serious cases may lead to criminal prosecution with unlimited fines. That said, if you're attending this webinar, you're well ahead of most landlords, and it's probably not addressed to you, these ones. But regarding rent repayment orders, so tenants, that includes former tenants, can apply to the first tier tribunal if you breach your obligations. They can claim up to 24 months rent, which is up from the current 12. Claims can be made up to 2 years after the tenancy ends, and these apply not only to landlords, but also to managing agents and company directors. So there's no corporate veil. So again, this is why your agent's professional indemnity insurance matters. For example, we carry PI insurance, client money protection, and redress scheme membership. So landlords are protected if something goes wrong. Other agents without these safeguards can leave you exposed to risks far exceeding any fee savings. Okay, let's break down what can constitute as a breach. So you leave today knowing exactly what to avoid. In short, anything that goes against your legal obligations as a landlord can be considered a breach. Have a look at the points on the slide to see the most commonly expected breach scenarios. If you have any concerns or questions about how this applies to your specific property, please book a call with us using the link below or next to the slides. Although the list may sound and look daunting, most of these things a managing agent should handle for you, or at least advise you on how to act. However, the ultimate responsibility lies with the landlord. So that makes your choice of the right agent all the more important. If your agent hasn't been discussing the act or how they're preparing, it might indicate they're behind the curve a bit there. I think what this list also shows is the sheer volume of compliance obligations that a self-managing landlord is now expected to track, document, and execute correctly. So each one of these is something that we as a standard would manage on behalf of our landlords. I'm going to jump to Martin now, who's going to give you his expert take on some of these matters. Martin, if you can take over.
Thank you. So the first thing I want to say to people is that there is a lot of fear and anxiety about this act, and I've seen a lot of friends who are landlords actually sell their portfolio, and I think that's very premature. As a lawyer, the regulatory requirements that you have to do anyway haven't changed, and if you are a knowledgeable or professional landlord, or you sensible landlord, you will know the regulations such as protecting the deposit, giving the information, prescribed information, and that is actually not changing. So yes, Section 21 is going, but it is being replaced with something that I actually think is arguably better and easier to use. Yes, the Act, like all new things, creates a mechanism that takes longer to enforce than if we'd left the old system alone. But in terms of things we have to do, the changes that are coming, one of them, the PRS, Private Rental Sector Database, I actually think is a really good idea. And the reason that I think it's a good idea is because before, let's just take the simple thing like the deposit. You've got to give the deposit, protect it within the 30 days from taking of the deposit, give the information to the relevant parties, the tenants and anyone who paid towards it, plus the PA, plus the how to rent guide. And if you don't do that in time, then there's a claim. They can claim against you for compensation, and that claim can be up to 2 years after they leave. So it's very easy, bearing in mind as a practice, we do about 1,000 cases a month. So, and we are one of the few practices that has our own integral counsel and advocates for the whole country. There's only about 3 in the country can do that. So we actually see the cases ourselves and do them in court. And it's really easy for tenants to say, oh, we were never given the deposit, or we were never given the prescribed information. And because the law requires it to be given, not served, and there's a big difference in those words, you've got to show that the tenant had it. Sometimes the cases get delayed to have a few things come to a later date to be sorted out. The whole thing for me about the PRS is once it's put there, if you put it on the PRS, that defence, that delay is going to be a thing in the past because it's there. So there's nothing they can say about it. And that's quite common. So I'm very comfortable with that. The second thing to say to you is that if you've got your agreement now, any pre-act agreements, post-act, the agreements aren't going to be made invalid. They're going to be valid and carried on. The only thing that will become invalid is if you have clauses in them that don't fit with the current act. For example, break clause, the break clause. So that will be invalid. If you have a rental increase clause, that will be invalid. But the remainder of the agreement will carry on as it is. So that's not really too much of a worry. In respect of the information sheet that you were told about earlier on, providing you've got an agreement in writing, then you must do it. And you can get that, either download it or get your managing agents to do it. But either way, that's got to be done. There is a cut-off for that. It is the 31st of May. You will have no excuse for not doing that. And it needs to be given to every tenant. So if you've got 3 tenants, that's 1 notice each. That's not 3 notices in 1 envelope. That's 3 notices in 3 envelopes for each tenant, or however many there are. It's an individual notice. Let's just have a look at the grounds, because really, if the tenant's paying the rent and you're happy, then you don't need anybody. You just sit back, make sure you have your repairs done in time, as you should do, absolutely fine. When things go wrong, the Act, as you've already heard, it creates 37 grounds up from 17. To be honest, it doesn't matter. Most of those grounds are sensible. Some of them are breakdown of grounds from before, and they just split them out into A, B, C. At the end of the day, there's the new ones aren't a thing to be afraid of. And we'll look at the first one, which is Section 8, Ground 1 and Ground 1A, which is effectively the replacement for Section 21. And they are that you want to move back in the property yourself or for a member of your family, or you want to sell the property. So member of a family is defined for once, quite easy. It's yourself, siblings, brothers, sisters, parents, grandparents, or going the other way, children and grandchildren. If you want the property for them to move back into, then that is Ground 1. Ground 1A is you want to sell the property and you're giving notice. Both of those notices are 4 months. But here's the thing, and it's really important to understand this. Once you have served those notices, from the date of expiry of that notice, 4 months' time, if they haven't moved or you haven't moved back in, or there's been a change of plan or the property hasn't sold, you can't go, okay, no, we'll remarket the property, because there is a ban. You may not rent that property for 12 months from the date of expiry of the notice. So you might want to be thinking that if you want people to move back in, before you zoom off and issue this Ground 1 or 1A notice, maybe have a chat with the tenant to see if there is a voluntary way that they will leave, rather than you putting this 12-month ban on renting after the expiry, because you're looking to 4 or 5 months ahead, because if they haven't gone, you're going to go to court, and that's going to add time. So, and things can change. And if you've issued the notice, you're committed. So yes, if you have to do it, do it. But have a think about it. Talk to the tenant first. See if there's a way to negotiate out to do it. I don't use the word buyout. That forms part of negotiation, but isn't an essential part of negotiation. So please think about that. 4 months notice, but that prohibition. And if you do, then you're asking for a several £1,000 fine. Not worth it. And you could be banned from renting if you're not careful going forward. So let's not go down that route. I'm not going to touch on student lets in this, because it's only a few people interested in that. But if you are interested, you have the chat, ask the question. They're going to send me the questions later on, and I will do an article for you on student lets. It's quite well documented, but too few people have an interest in that. We've touched on ground 8, the mandatory ground, the most common ground used. We use as lawyers ground 8, 10 and 11. 8 is now going to be at least 3 months rent and 4 weeks notice. 10, some rent, doesn't mean less than 3 months. It can be as many months as you like, but that is some rent. And then 11, persistent arrears. Missing 1 is not persistent. Missing 2 is arguable. Missing 3 is persistent. They don't have to be consecutive. It can be pay a couple, miss 1, pay a couple, miss 1, pay 1, miss 1. So it's over a period of time. It's not a consecutive thing. They're all 4 weeks notice and 3 months to be for the ground 8 in arrears. That means that the time from the first missing of the first rent to actually getting to court, or no, let's rephrase that, to actually being issued at the court, because the court hearings vary from court to court, waiting times vary from court to court. But to issue is going to be 6 weeks longer than it has been to date, which means automatically the rent arrears are probably going to be at least 1 month and probably 2 months more than they would be. So the amount of debt that the courts are going to deal with is going to be much higher, which means that when you do get to court, bearing in mind that Section 21 applications generally didn't have a court hearing, and now under Section 8, ground 1, they are going to have a court hearing. The courts are going to be a bit more inundated than they are now. Don't get me started on that one. Another common one, ground 12, is a breach of tenancy. Breach meaning other than rent arrears. So no smoking, no pets anymore. If you've got a no pets clause in your agreement, that's just going to be void. But no alterations, no subletting, that's very common. No smoking is very common. No water beds, that's a common one for some unknown reason. If that's happening, then that's a breach of tenancy. Oddly, that's 2 weeks notice. Yet they are in a minority, and that would seem to be nowhere near as serious as missing 3 months rent. But there you are, that's how it goes. And ground 14 has changed. Ground 14, so antisocial behaviour, property being used for illegal or immoral purposes, used to be 14 days. That's changed, and that's now called on notice. As soon as it's served, you can start, and you can ask for an abridged hearing date as well. Whether you get it, another matter or not. But if it's a criminal act, for example, they've been convicted of a crime, ground 14 is not your best one. It'll be ground 7. Just be aware that you can use ground 7, but the criteria for using ground 7 is quite strict. And so if you want to use that, talk to us before you can start going down that route. They are the key ones that you need to know. I think that's all I need to do for the moment. And then I will talk about other things as they come up.
Yeah, sounds good, Martin. Thank you.
You're welcome.
Really insightful. Thanks. Perfect. So I want to end the main content on something positive because, like Martin said, it's not all doom and gloom. And despite everything that we have covered today, this is a market with really strong fundamentals and a real opportunity for landlords who are prepared. The demand picture is exceptional. On average, there are 11 applicants for every available rental property across England. In London, the competition for good stock is even higher. Demand is not going anywhere. If anything, the supply of rental properties is tightening as some landlords are choosing to exit, which strengthens your position as someone who stays in the market and stays professional. The average annual rental yield across England is 6.3%. Compare that to savings rates or compare it to most other asset classes, it remains a very competitive return. So here's an opportunity that very few people are talking about. As landlords who find the compliance burden too great choose to exit, their properties are coming onto the market. So for landlords who have the right professional infrastructure in place, the right agent, the right insurance, and properly managed portfolios, this is a real window to grow. To acquire good stock at competitive prices from people who might be selling out of anxiety rather than any financial necessity. So a good managed service like our full management packages means you can approach growth with confidence. You know your income is protected throughout the possession process if it's ever needed, and with proper referencing in place, that risk is already very low. Altogether, it makes expanding your portfolio far less risky and stress-free. Well-managed, compliant properties with a professional agent handling it all, those are the properties that are going to attract the best tenants, achieve the best rents, and have the lowest void periods. They also carry the lowest legal risk. So to landlords who will thrive over the next decade are those who are going to treat this as a business by investing in professional management to protect their income. So Yasmin's going to talk to you about what this means for you.
Thank you, Melissa. So to talk practically now about what all of this means for how you manage your properties going forward, and I'm going to be honest with you rather than just selling our services. 43% of landlords have already considered using a professional agent specifically because of this legislation. In my view, given everything we've just walked you through, that number should be 100%. Not because I work for an agency, but because the compliance burden is now too significant to manage alone without real risk of getting something wrong. When you're assessing an agent, and I'd say this whether you're thinking about us or anyone else, have a look at the checklist on the screen now to give you an idea of what should be included as a minimum standard. What sets us apart is how hands-on we are. Many landlords on this call have already joined us through our management takeover scheme and would agree that our priority is providing real support and peace of mind. We handle all day-to-day management, compliance, works, Section 13 notices and market comparables, along with standard property management, and offer expert legal support where needed. Most importantly, our management packages are genuinely all-inclusive. Relets are included, with no extra charges for drafting contracts or deposit protection. We also guarantee your rent with fully referenced professional tenants. You're paid by us without delay while we wait for the insurance payout if required. Legal expenses are included as part of this package. And I want to address something I hear often. Landlords say, I'd rather do it myself to save money. And I understand, but cutting costs is always expensive. A saving of £100 a month in management fees, which is £1,200 a year, is nothing against a single £7,000 fine, or a 12 months arrears battle, a rent repayment order going back 2 years on a portfolio of properties. The right agent doesn't cost you money, it protects the money you've already invested. So before we get to the Q&A, we want to tell you what working with us actually looks like, because really after a session like today and the information you've been given, I think the question isn't whether you need professional full management, it's whether we're the right agency for you. So we've been supporting landlords for 40 years. We've been through every single piece of legislation on that timeline, and we've protected our landlords through every one of them. When deposit protection came in, our landlords were compliant from day one. When EICRs became mandatory, our landlords were already compliant. We don't react to legislation, we prepare for it. Our full management service has been adapted specifically around what the Renters' Rights Act requires. And what it will require is it phases in over the coming years. We handle full compliance management for the transition. Every information sheet, every written statement, and all of our contracts are being updated from ASTs to APTs. So that's the new form, Assured Periodic Tenancies. We'll handle PRS database registration when it launches. We coordinate maintenance proactively to protect you from AWAB's law exposure, and we include rent guarantee insurance options to protect you from Section 8 changes. All of that, plus the standard property management mentioned on the previous slide, is included in our management takeover scheme. And we're currently offering a discount on this with tenanted properties where landlords don't want to self-manage anymore. So you can reach out to us today. I think my colleague will pop the link below to be eligible for the discounted rate. This is valid for a limited time only. It's so we can help you be compliant before the 1st of May and when a lot of stuff needs to be done. You can also, if you want to talk about your specific portfolio, maybe what you have, where it is, what the current arrangements are, you can also reach out via the link below or to me or Melissa directly. Our contact details will come through with the recording of this webinar. We're happy to have that conversation with no obligation. The recording will be with you within 48 hours, and a massive thank you to Martin Ashley-Taylor for giving his time and his expertise today. And to all of you for attending. We will open up for questions, but as Martin said, he won't be answering any of them live. He'll respond to those in email in due course. So again, with the questions, we don't have too much time for too many. We'll take a couple. I can see our moderators have gone through and answered to some that have been coming through already. There are no silly questions, and I hope everyone feels comfortable sending through what you can. If you're thinking about a question, I promise you someone else listening is probably thinking it too. So we'll just wait a couple of minutes to see what else comes in. If not, I'll go through and answer a couple of these ones that have come through before we wrap up. In the meantime, while we wait to answer those, we will be hosting another Renters' Rights Bill webinar at the end of April, as we did hit the capacity on this one, unfortunately, so a few people couldn't join on. And we're also going to be running some additional webinars, including one on making tax digital, which is obviously affecting landlords at the moment. We will have a direct integration into our system to simplify the process for our managed landlords. We're also, everyone's jumping on the webinar trend, our sales director and our mortgage advisor will be doing one to sort of advise on the sales market and how that's been shifting, and that's going to be for people considering selling or buying. So let's pick through. Okay, so Ryan has asked, what do I do about rent increases? I have a rent review clause in my existing tenancy. What happens to it now? So obviously from the 1st of May, as we've kind of mentioned, rent increases must only be done using the statutory Section 13 process that Martin went into more detail for. Any contractual rent review clauses in agreements will no longer have effect, and they will be void. So yeah, you can't do anything about those clauses anymore.
It's invalid.
Yeah, exactly.
I think Julia's got a good question. Do I need to reissue all of my tenancy agreements? No, you don't need to reissue them. They're going to convert automatically to periodic. It's a good idea to make sure that you have all written agreements in place, because I think, like Martin mentioned, verbal agreements won't be accepted. And then you just need to serve the written information sheet before the 31st.
Yeah, well, the verbal agreements won't be accepted for the information sheet, but you will have to supply a document giving the details of the tenancy within the same thing.
Yeah. I'm
looking at a question here. If I rent out room by room and I want the tenant to move out, from Mario, you can rent by room by room. It has always been so. It's misunderstood. You can rent a room, providing that room has, there's 4 criteria to make a tenancy, one of which is called exclusivity. And exclusivity is proven by controlled access to the room, i.e. key. So if you're renting out by room, it doesn't matter the facilities are shared, because the definition of where you rent is where you sleep the most. So if they sleep in that room and they've got a key to that room, which gives them controlled access, it's entirely possible to have several rooms in the house with several different people, all with what will be new tenancies. Don't forget, you're going to have an HMO license if you've got multiples. If you've just got one room and you're letting out that one room and it fulfills the criteria, which we don't have time for here, but one of it is exclusivity of the key, and they can control access, then that one room could easily be an APT, in which case you have to deal with it as if it is. So the answer, if you want them to move out, then you're going to want access to live back in the room or bring the room back into your family. Or if you want it because you want other people to go in, that's not going to happen anymore.
Yeah, great. I think Alpi's got a question about HMOs. On that note, actually, if your property is in Hackney, 1st of May onwards, they're bringing back selective and additional licensing. So
wonderful.
Something to think about. Yeah. Do we want to, I think quite a few questions are coming in now. Shall we leave this open for another 10, 15 minutes, give everyone a chance to ask all their questions? we will definitely get back to you. I think we're aiming to send the webinar within 48 hours, the recording anyway. And then questions we'll answer, and any directed to Martin, we'll make sure that you get the
Send
response
some to me
as
and
well.
I'll deal with it. You won't get them till early next week, because you may have noticed I'm not in country.
Exactly. So that's fine, Martin. We appreciate that.
Martin's very kindly joined us from Portugal today, so thank you very much, Martin.
All right.
Brilliant. All right, we'll keep the chat open. So please put through your questions. Like Melissa said, we will respond to everyone and send out all the answers shortly after this webinar, as well as Martin with a slightly larger time frame for him to send it back. But thank you very, very much, everyone, for joining. We hope you've enjoyed it, and it's been really, really useful. And yeah.
Thank you, Martin. Thank you, everyone.
You're welcome.
Thank you.
Don't worry, people. It'll be good. It'll be okay. Thanks. Bye now.
Thank you,
Bye-bye.
Martin. See you. Bye-bye.